go to Arson, Articles 320 to 326B has already been repealed by PD 1613. But after PD 1613 repealed Articles 320 to 326B, here comes RA 7659. RA 7659 amended Article 320. So, Article 320 is still alive. And Article 320 punishes destructive arson, whereas PD 1613 punishes simple arson. Arson is the malicious destruction of property by means of fire. In arson, you have only two things to prove. First, proof of the presence of burning of property by means of fire. And second, the property burned are those enumerated under Article 320 for destructive arson and those enumerated under PD 1613 Section 3 for simple arson. If what has been burned is an inhabited house or dwelling, the crime committed is only simple arson. The helper of the house who was denied a Christmas vacation by the master was mad at the master. And he wanted to get even at the master. So he decided to leave the house. But to take revenge, to get even, he decided to burn the house. But he doesn't want to kill his master and the family. His only intention was to burn the house. And so he set the house on fire, but before leaving, he made so much noise so as to awaken the master and the members of the family. Unfortunately, the master and the members of the family were not awakened. And so together with the house, the master and the members of the family were all burned to death. Not only that, it was a huge fire. 5 other houses nearby were also burned. The said servant was arrested. What crimes may be filed against the said accused? He can be charged of the crime of simple arson. Why simple arson? 5 people died, the master and the members of his family. 5 other houses aside from the said house of the master had been burned. Why only simple arson? Because you take into consideration the intent. The intent of the accused was to set this house on fire, to burn the house. Therefore, it is only simple arson. The fact that people died in the course of the said simple arson would only increase the imposable penalty to reclusion perpetua to death. But there is no such crime as arson with homicide. Arson with multiple homicide. There is no such crime. The crime is only arson, and the fact that 5 people died, it will only increase the imposable penalty. The penalty for simple arson is reclusion temporal to reclusion perpetua. If a person died, it will be reclusion perpetua to death. The same theory applies to destructive arson. If in the course of burning a building used for public purposes, unknown to the said offender, someone was inside, the guard was sleeping inside, the building for public purposes was burned together with the security guard. What crime is committed? Destructive arson. The fact that the guard died will only increase the imposable penalty to death. The penalty for destructive arson is reclusion perpetua to death. If someone is killed in the course thereof, then the penalty will be capital punishment or death penalty. X wanted to burn the house of Y. What X did, about 5 o'clock in the morning, X went to the house of Y. He has brought along hays and straws. And he placed this hays and straws surrounding the house of Y. Thereafter, he brought a can of gasoline and poured gasoline on this hays and straws that he placed surrounding the house of Y. He was about to set it on fire. He was about to light it and set it on fire. But here comes the owner Y. When X saw Y, X hurriedly ran. He doesn't want Y to see him, and so X hurriedly ran. Is X liable of any crime? X is liable of attempted arson. The act of X, placing haze and straws around the house, pouring gasoline, about to set it on fire, these are overt acts directly connected to arson. However, he wasn't able to perform all the acts necessary to consummate arson by reason of a caused accident other than his own spontaneous resistance. It was purely accidental and causal that the owner arrived. Hence, the crime committed is attempted arson. What if in the same problem, after X, intending to burn the house of Y, had placed straws and newspapers and haze around the house, poured gasoline, and he set already the said haze and straws on fire. The haze and straws around the house are already burning. Here comes the owner Y. He suddenly arrived. X, upon seeing the owner, hurriedly left the place. Y, seeing that there were haze and straws around his house, and they were on fire, immediately called the neighbor for help, and they were able to put out the fire. What crime or crimes had been committed by X? X is liable for attempted arson. The act of X, placing haze and straws, pouring gasoline, lighting it, setting it on fire. The haze and straws that he placed were already burning. These are overt acts directly connected to arson. However, he wasn't able to perform all the acts of execution because it was purely a cause or an accident that the owner Y arrived, and together with the neighbors, they put out the fire. But what if, in the same problem, X placed haze and straws around the house of Y, intending to burn the house of Y? He poured gasoline, set it on fire. It was already burning. And because of the fire created in the said haze and straws, the wall of the house of Y was already on fire. Here comes Y. He suddenly arrived. X, upon seeing Y, hurriedly ran away. And Y called the help of the neighbor. With the help of the neighbor pouring water, they were able to put out the fire. But the wall of the house of Y was already damaged because of the said fire. What crime or crimes had been committed by X? X is liable for consummated arson. To consummate arson, it is not required that the entire property be burned. It is not required that the entire house, the entire building be burned. It suffices that the said building is damaged, that the said house is damaged by means of fire. So here, the fact that the wall had been burned, the house of Y had already been damaged by means of fire. Therefore, X is already liable for consummated arson. So in this case, because of the manner committing arson, there cannot be a frustration in the crime of arson. X and his boyfriend broke up. X was so sad, he wanted to forget her boyfriend. And so what X did, he took all the love letters, all the stuffed toys, all the dried flowers and leaves, and thereafter, he placed it in the backyard on a box and set it on fire. With that burning, the love will become. He will be forgetting. He will be forgetting the boyfriend. And so, he put fire on it. Thereafter, after everything were already ashes, X left. But there was a strong wind, a very strong wind. And this strong wind blew away the said ashes of the said papers, stuffed toys, everything. And it is still little light and little fire. And this fire hit a paper, and the paper hit a wood, and it was in the house, and the house was burned. Is X liable of any crime? X is liable of reckless imprudence, or not simple imprudence, resulting in arson. Is X liable of arson? X is not liable of arson. The reason is, it is not unlawful. He was not committing a felonious act. She was not committing a felonious act when she was burning these papers, these love letters, etc. Therefore, she cannot be held liable for arson under the proximate cause doctrine. Because in the first place, she was not performing a felonious act. However, although she was performing a lawful act, she did not do it with due care. After, she should have poured water and make sure that there are no longer any traces of fire. So because of her negligence, arson was produced. Hence, the crime committed is simple imprudence resulting in arson. If a person caused damage to the property of another, deliberately damage the property of another by any means outside arson, the crime committed is malicious mischief under Article 327. Just like mutilation, malicious mischief requires deliberate intent. There must be a deliberate intent to damage the property of another. Therefore, absent the deliberate intent to cause damage to the property of another, there is no crime of malicious mischief. So, X, in the course of a fight with Y, gave Y a very strong kick. Y landed on the fence of W. The fence of W was broken. The fence of W made of a piece of wood was broken. W was mad at X. He wanted to file a case of malicious mischief. Can he do so? He cannot. X will be acquitted because X has no deliberate intent to damage the personal property, the fence of W. The only case that W may file against X is damages, a civil action. Insofar as malicious mischief are concerned, there are the so-called qualified malicious mischief. In the following instances, these are the so-called qualified malicious mischief. Causing damage by obstructing public performances. Causing damage by using poisonous or corrosive substances. Causing damage by spreading infection or contagion among Catholics. Causing damage to the property of the National Museum, National Library, or any archive, registry, waterworks, promenade, roads, or anything used in common by the public. Outside this, we have only simple or ordinary malicious mischief. Under Article 332, the law provides for an absolutory cause. Under Article 332, no criminal liability but only civil liability shall arise from the commission of the crimes of theft, swindling, or malicious mischief between and among the following: spouses, ascendants and descendants, relatives by affinity in the same line. Also, the widowed spouse with respect to the property of the deceased spouse before the same has come into the possession of another. And lastly, brothers and sisters, brothers-in-law and sisters-in-law if they are living together. If a stranger conspired with a relative in the commission of theft, swindling, or malicious mischief, this absolutory cause would not apply to the said stranger. Therefore, the stranger shall be held liable criminally. In the case of intestate estate of Manolita Gonzalez, Viuda de Calungong versus People, the Supreme Court said, the absolutory cause in Article 332 applies only to simple cases of theft, swindling, and malicious mischief. Therefore, the moment theft, swindling, and malicious mischief is already complex with another crime, the absolutory cause would no longer lie. That brother, that spouse, that descendant will be both criminally and civilly liable the moment the simple case of theft, swindling, and malicious mischief are already complex with another crime. You have 15 minutes break.
Thank you, Ma'am.